Mr. President, I note my colleagues have come before me to discuss the nomination of Brett Kavanaugh to fill the vacancy on the United States Supreme Court for the retirement of Justice Kennedy. I checked just to make sure I understood the section of the Constitution. It's Article 2, relative to the President's powers, which talks about the power of the President to fill that vacancy on the Supreme Court, subject to the advice and consent of the United States Senate. 100 United States senators ultimately have the last word on any nominee. I'm fortunate to serve on the Senate Judiciary Committee, where we get the first chance to review any nominee and take a look at their backgrounds and vote as a committee before the matter is brought to the floor of the United States Senate. I've listened to my colleagues who support Judge Kavanaugh ascending to the bench to a lifetime appointment to the highest court of the land. I'm troubled by one particular aspect of this nomination. It is different than any nomination in the history of the United States to the Supreme Court. Different in this respect. This president made it clear that any person who wanted to be eligible for the United States Supreme Court needed to pass a clearance by two organizations. One is called the Federalist Society, and the other is a Heritage Institute. Both of these are conservative organizations which reviewed all of the potential Supreme Court nominees and produced a list of 20 or more men and women who would be eligible for the Supreme Court by their judgment. Is their judgment important? I'll point to one fact in history which illustrates. When Neil Gorsuch was nominated by President Trump to serve on the Supreme Court and fill the vacancy of Antonin Scalia, he was not notified by the White House. The White House called the Federalist Society head, Leonard Leo, and asked him to call Mr. Gorsuch and tell him the good news. So to say that the Federalist Society and Heritage Institute play a critical role in the selection of a nominee is an understatement. If you don't clear their background test, their litmus test, you cannot be considered by the Trump administration for the Supreme Court. That's offensive to me. You don't see any reference to the Federalist Society or the Heritage Institute in the United States Constitution. There's a clear reference to a president elected by the people of the United States. But to give to any special interest group, right, left, or center, that kind of authority is way beyond what our founding fathers imagined would be this process for selecting someone for the Supreme Court. But then it gets even more complicated. Before we consider a nominee for the Supreme Court, we have to carefully review their records. It takes time. Literally scores of lawyers sit down and go through the published opinions and speeches and other documents which evidence a person's background. And when it comes to Brett Kavanaugh, it's an extensive background. He's had a role at the highest levels of the federal government for years. Kenneth Starr's Special Commission, the Gore and Bush lawsuit that went down to the state of Florida and beyond. The cases that he was involved in as a member of the court are pretty obvious and published. But many of his activities, particularly in the White House when he served as a staff secretary to the President of the United States, were extensive for a 3-year period of time. 35 months, he was the gatekeeper in the White House as to the documentation which the President would receive and read. It involved a pretty massive amount of time and documentation on all of the major issues facing the presidency for almost 3 years. Should we take a look at it? Is it worth our investigation and inquiry into what Mr. Kavanaugh said and did during those years? Well, there was a time here when the Republicans thought it was not only important, but essential when it came to a nominee named Elena Kagan. Elena Kagan had never served on the Supreme Court or federal judiciary. She was nominated by President Obama, and at the time, the ranking Republican on the Senate Judiciary Committee, Jeff Sessions of Alabama, insisted on the full documentation of her role in the White House. And the Democrat on the committee, Patrick Leahy of Vermont, joined him in making that request. 170,000 documents were produced because of Senator Sessions and Patrick Leahy's request. It was a bipartisan request. It established a standard. The same standard was applied for the next Democratic nominee, Sonia Sotomayor. Documentation had to be presented to the committee and carefully reviewed before there was a vote on whether that person would serve in a lifetime appointment to the highest court in the land. Most of us assumed at that point that it was a settled practice in the United States Senate Judiciary Committee when it came to the documentary proof we would ask for when nominees came before us for the Supreme Court. We thought that, but we were wrong, because when the Republicans took control, everything changed. It changed, of course, with Anton Scalia's vacancy, untimely death, a vacancy which President Obama sought to fill during his last year in office. He ended up nominating Merrick Garland, a D.C. Circuit Court judge of impeccable credentials, to fill the vacancy. The Republicans in the Senate refused to even meet with Merrick Garland, let alone consider him and vote on him. So for a whole year, the vacancy continued on the Supreme Court while the Republicans broke Senate tradition and refused to consider President Obama's nominee. Then came the election of Donald Trump, the nomination of Judge Neil Gorsuch, and the process went forward to fill the vacancy, which the Republicans had kept open for more than a year before Neil Gorsuch was finally voted on by the United States Senate. So here came the second vacancy under the Trump administration, a vacancy created by the retirement of Justice Kennedy, and the question was obviously asked, what standard will you use for asking for the documentary evidence of the person's background in public service? Many of us assumed it would have been the same standard that was pushed by Senator Sessions, Republican of Alabama, and Senator Leahy, Democrat of Vermont. We were wrong. Instead, what the Republicans said is we're going to have a new rule when it comes to Republican nominees from the Trump administration in the case of Judge Brett Kavanaugh. And that new rule said that we will not ask for documentation for the 35 months when he served in the White House as the closest advisor to the President of the United States. I can tell you there were a myriad of issues that were considered by the President in that period of time, and Brett Kavanaugh, then assistant to the President, was involved in these decisions. We won't know what he said or did because the Republicans have refused to ask for the documentary evidence of his time there. But there's more to the story. They decided that for those documents which they might consider asking, they would have a final filter. And the final filter is a man named Burke, who has served as a counsel, an attorney, for not only President Bush, but also in the past for Steve Bannon. Does the name ring a bell? Steve Bannon of Breitbart News. He has served as his counsel and was assistant to Brett Kavanaugh in the White House. Mr. Burke is literally going through the documents to decide which ones will be given to the Senate Judiciary Committee to consider. So it means that he is the filter of things that he doesn't want us to see, doesn't want the American people to see. This Republican advocate attorney is going to be a decision maker when it comes to whether or not we can see documents that were produced by Brett Kavanaugh when he served in the White House and beyond. And it's even worse. It turns out that those documents which he pre-clears for us to read in the Senate Judiciary Committee are subject to some sort of committee confidentiality. Now, I've served on the Senate Judiciary Committee for a number of years, and I know that there are documents which are considered somewhat committee confidential, but it's rare. And it's usually a case which you wouldn't argue over, classified information, for example. In this case, the Republicans on the Senate Judiciary Committee will be the final filter as to whether or not the American people will know the background of Brett Kavanaugh. Why is there so much secrecy here? Why wouldn't these documents be made public? Well, let's look back in time. When Elena Kagan was asked to produce 170,000 documents from the time that she served in the White House, she produced every one of them. On how many of those did she assert executive privilege and say, I can't produce them? None. Every single document was turned over to the Senate Judiciary Committee. Now, when it comes to Brett Kavanaugh, I can't tell you what's going on here. There is a concealment which is impossible to explain. What would we find in those documents that have been carefully screened by Mr. Burke and then again by the Senate Judiciary Committee Republican majority? I'm concerned about it because this is a lifetime appointment to the highest court of the land. We know the court's carefully divided. It is legitimate for us to ask the questions about Judge Kavanaugh's background because of our constitutional responsibility to advise and consent. But we can't ask those questions if they don't produce the documents. And that's where we are today. So my colleagues can come to the floor and talk about Judge Kavanaugh's record leading up to this nomination. They are limited in the information they've been given, and the limitations are unprecedented in the United States Senate. The Republicans, when it comes to the Supreme Court, just rewrite the rules. Merrick Garland, President Obama's nominee, sorry, no thanks. We're not interested in interviewing him or even considering him for that appointment. And when it came to this judge, Judge Kavanaugh, the ordinary production of documents by a standard established by the Republicans, Senator Sessions, are being ignored now when it comes to the nomination of Brett Kavanaugh. Nevertheless, we'll be given limited information because of this process and have to do our best to carefully review this nominee before he is considered for this lifetime appointment to the highest court in the land. Mr. President, I yield the floor and suggest the absence of quorum.